Hi, professional. This is CA Rohan R. Pingai. Welcome to my channel, CA Rohan Pingai. And today onwards, I'm going to start video series on indirect tax, case laws, and that is uh, what law says. One video series we have already started under direct tax, and now from today onwards, it is related to indirect tax. And we under that we will discuss few of the GST cases taken place at High Court. So let me allow to share my screen. Hope you are able to see my screen. What law says? Indirect tax part 1. Let's begin. First case. Xilinx India Technology Services Private Limited versus Special Commissioner Zone 8 2023 78 GSTL 24 Delhi High Court, and date of order is 1st September 2023, and relevant section is section 2 subsection 6 clause V of IGST Act 2070. Let's understand facts and issue of the case. Petitioner export-oriented unit providing intercompany services to its holding company in USA. Petitioner filed an application for refund of IGST. What petitioner had done is filed an application for refund of IGST, which was rejected by the respondent, that is department. Show cause notice was issued contending that the condition under section 2 subsection 6 clause V of the IGST Act not satisfied. What they had contended, the respondent contended that the condition under section 2 subsection 6 clause V of the IGST Act was not satisfied. Reply filed by petitioner where it was clarified that supply of service by subsidiary of foreign company to its holding company would not be barred by the conditions stipulated under that section. What petitioner was replied that the supply of service by subsidiary of foreign company to its holding company will not be barred by the conditions stipulated under section 2 subsection 6 clause V of the IGST Act. Even then, respondent passed an order rejecting the refund. Then Delhi High Court observed and held that services provided by subsidiary of a foreign company to its holding company are not covered under Section 2, subsection 6, Clause V of IGST Act 2017. So Delhi High Court what observed and held that services provided by clearly held that services provided by subsidiary of the foreign company to its holding company are not covered under section 2 subsection 6 clause V of IGST Act 2017. Impugn order was passed mechanically without application of mind, ignoring and disregarding the basic provisions of law and circular. The respondent was directed to process the refund along with the interest. Let's move on the second case. Modern Insecticides Limited versus Commissioner CGST 2023-78 GSTL 423 Punjab and Haryana High Court. Date of order 19th April 2023, and relevant section is section 74 of CGST Act 2070. Let's understand facts and issue of the case. Petitioner was a manufacturer of pesticides. Search operation was conducted on the factory premises of the petitioner. Respondent seized all the documents and prepared Panchanama on the same day. Respondent created an artificial shortage of the goods without actual stock count, which involved the GST and penalty amount. Petitioner deposited the amount under pressure. Subsequently, second search was conducted wherein director and CEO of the petitioner were detained. Both were released on a condition of a deposit of rupees 2.15 crore, which was paid by reversing the ITC and surrender of refund application filed. Petitioner requested to refund of rupees 2.45 crore as no proceedings were initiated by issuance of notice and no summons were issued under section 74 of the Act from search to the date of deposit. Respondent contended that since petitioner had deposited money voluntarily, no notice was required to be issued. So what respondent means, department contended that since petitioner had deposited money voluntarily, no notice was required to be issued. However, being aggrieved, petitioner preferred this petition before the Honorable High Court. Let's see what High Court observed and held that replying upon the decision, sorry, replying upon the decision of Delhi High Court in case of Vallabh Textiles versus Senior Intelligence Officer and others 2023 70 STL 3 Delhi, held that amount deposited during the search operation cannot be considered as voluntary. What High Court observed and held that amount deposited during the search operation cannot be considered as voluntary. Department cannot issue form GST DRC 01A for tax recovery since no proceedings were initiated by the department till date. Accordingly, the department was directed to refund the deposited amount along with interest. So it is in favor of the assessee. Let's move on next. Sham Sale and Power Limited versus State of UP 2023-78 GSTL 283 Allahabad High Court. Date of order 5th October 2023. Relevant section 129 subsection 3 and section 130 of CGST Act 2017. Let's understand facts and issue of the case. Petitioner was engaged in manufacture and sale of industrial grade steel components. Goods sold by petitioner was in transit. Goods sold by petitioner was in transit and carrying all the necessary documents. Subsequently, goods were intercepted by concerned authorities on the way, and on verification of it was found that e-way bill had been cancelled by the purchaser without informing the petitioner. Goods were seized and MOV 07 was issued seeking response from the petitioner. In response, petitioner submitted that all e-way bills were filled up and they were unaware that the same were cancelled by the purchaser was rejected. What response petitioner had submitted that e-way bills were filled up properly, but they were unaware that the same were cancelled by the purchaser. Order in form MOV 09 was passed and penalty was imposed. Subsequently, an appeal filed by the petitioner was rejected and therefore a writ petition was filed before the High Court. Allahabad High Court observed and held that High Court, relying upon decision of Apex Court in case of Assistant Commissioner ST versus Satyam Shivam Papers Private Limited 2022, held that there was no intention to evade tax and goods in question didn't reach the destination only due to circumstances beyond the control of the petitioner. Means there was no intention to evade tax, and whenever goods in question didn't reach the destination only due to circumstances beyond the control of the petitioner, and no such intention was observed to invoke proceedings under section 129 subsection 3 and section 130 of the CGST Act 2017. It was a minor breach and proceedings should have been initiated under section 122 of the CGST Act 2017, and therefore impugn order was set aside. Next, M. Sathesh versus Deputy State Tax Officer 2 2023 78 GSTL 388 Madras High Court. Date of order 30th August 2023, and relevant section is section 73 of CGST Act 2017. Let's understand facts and issue of the case. Petitioner was engaged in providing works contract services to the government, departments, and local bodies. Subsequent to the increase in the rate of GST from 12 to 18%, notice was issued by department stating that petitioner had not paid excess liability. Okay, what department is saying that after increase in rate from 12 to 18%, petitioner had not paid excess liability. Petitioner submitted a reply on 24th July 2023, but an order was passed by a respondent on 25th July 2023 on the very next day without considering the reply submitted on the ground that petitioner failed to appear and submit their reply during the three personal hearings granted previously. Aggrieved read petition was filed before the High Court to quash the impugned order by the petitioner. The Madras High Court observed and held that order was passed by violating the principle of natural justice, and the respondent is bound to consider the response submitted by the petitioner, means appellant, before passing any impugned order. Correct. And then respondent to grant one or more opportunities for personal hearing before passing a speaking order. His Madras High Court straightly observed and held that they have his department has violated the principle of natural justice, and they have not given the chance opportunity of hearing, and therefore they have violated this provision, and therefore they have passed the order in favor of assessee. Next, Rani Madras Limited versus Assistant Commercial Tax Officer, Appeals 2023-2077, GSTL 382, Madras High Court again. Date of order 2nd August 2023, and relevant section is section 107 of CGST Act 2017. Let's understand facts and issue of the case. Petitioner attempted to file an appeal against the Trans-1 rejection order dated 20th February 2023 electronically as per Rule 108 of CGST rules. Due to technical glitches on the portal, the petitioner unable to upload the appeal. And another attempt was made, which was also unsuccessful. Subsequently, petitioner filed a complaint on the portal, to which there was a reply from GST help desk that trans 1 or 2 order are not enabled for appeal on GST portal, and petitioner was asked to wait. Meanwhile, the petitioner filed an appeal manually, which was rejected by respondent by issuing order on the ground that appeal was filed after time specified under section 107 of CGST Act 2017. Aggrieved writ petition was filed before the High Court. Madras High Court observed and held that appeal should not be rejected on the ground of delay, where due to absence of facility on GST portal, appeal was filed manually. That is as simple as that. Because GST portal facility was not available with the assessee, assessee has filed manually. So he has complied with something actually. Petitioner had already complied with notification number 29 of 2023 Central Tax dated 31st July 2023. Any appeal filed before issuance of this notification was considered to be filed on time, and hence cannot be rejected on the basis of delay in filing as per section 107 of the CGST Act 2017, and respondent directed to dispose of the order on marriage. Next, Riddhi Infratech India Private Limited versus Commissioner Commercial Tax 2023 157 taxman.com 278 Allahabad High Court, and date of order is 23rd February 2023. and relevant section is section 61 of CGST Act 2017. Let's understand facts and issue of the case. Notice under section 61 of the CGST Act 2071 was served upon the petitioner claiming that turnover in the annual return in form GSTR 9 doesn't tally with his bank statement. The demand was confirmed by both the original as well as appellate authorities. The demand was confirmed both by original as well as appellate authorities. The petitioner contended that the very basis of the notice is wrong, since in his GSTR 9, the turnover is shown as only with regard to supply made to unregistered person, that is under the B2C category. It was thus contended that by the petitioner, the authorities didn't read the form as a whole. What Allahabad High Court observed and held that the authorities concerned failed to take into consideration the entire form and have committed the said misreading of GSTR 9. Both the orders are liable to be set aside. Next. Sign Automation and Integration Private Limited versus Union of India 2023 157 taxman.com 259 Bombay High Court. Date of order is 29th November 2023 and relevant section is section 54 subsection 3 of CGST Act 2017. Let's understand facts and issue of the case. Petitioner filed a refund application for the period. Petitioner filed refund application for the period April 2018 to July 2019 for unutilized ITC under section 54 subsection 3 of the CGST Act 2017 on export of goods under letter of undertaking. Included therein ITC attributable to financial year 17-18, which was standing to the credit of the petitioner in the form of running account. Okay. Order rejecting the refund on the ground that it was not permissible for the petitioner to club both the periods. So that refund or application is rejected. What Bombay High Court observed and held that credit which was available for the period prior to 1st April 2018, credit which was available for the period prior to 1st April 2018 pertain to the financial year 17-18, same was certainly available to the petitioner in its electronic ledger in the form of running account. Such refund cannot be denied. That is the simple way of looking. The same way means it is available in its electronic ledger in the form of running account. Then why refund will be denied? So the refund cannot be denied. What the Bombay High Court held. Nemi Pharma Chemical versus Additional Commissioner of CGST and CX 2023 157 taxman.com 478 Bombay High Court. Date of order 14th December 2023 and relevant section is section 75 subsection 4 of CGST Act 2017. Let's understand facts and issue of the case. The petitioner was issued a show cause notice. However, there was no compliance of the said show cause notice by the petitioner. The petitioner filed a letter requesting the respondents to provide a copy of the said show cause notice, since the address at which it was issued was no more occupied by the petitioner, and also requested for an adjournment of 30 days. His first petitioner issue show cause notice, he had not compliance with that show cause notice, but then he filed a letter requesting the respondents to provide a copy of the said show cause notice, since the address mentioned was issued no more occupied by the petitioner, and also requested for an adjournment of 30 days. Respondent handed the hard copy of the show cause notice and passed an order without following the natural justice. So, what Bombay High Court observed and held that the impugn order came to be passed within 2 weeks from the date of application for adjournment without the respondents replying to the request for adjournment of the petitioner. Means what Bombay High Court observed that the department actually passed the order without looking the adjournment application, without considering that adjournment application. The court further held that the respondents ought to have also complied with provisions of Section 75, subsection 4, and provided an opportunity of being heard for any adverse decision was contemplated against such a person. Means whenever adverse decisions against the assessee, what department has to do, they have to give an opportunity of hearing under Section 75, subsection 4. So court further held that the respondent ought to have also complied with this provision, and they all should provide an opportunity of hearing where an adverse decision was contemplated against such a person. The High Court held that since there has been a violation of principles of natural justice and the mandatory provisions of Section 75, subsection 4, the impugn order was quashed with a direction to decide the matter afresh. So, this was for the today. This was the first video on indirect tax GST case laws, and there will be a much more coming on my channel. So please do subscribe. If you like this video, do share in our network, because professionals must be updated, keep updated themselves by taking time to prosper in their practice. So this is for today. Thank you so much for patience listening. Thank you. Thank you so much. See you soon.